Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. Happy New Year's to everyone. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come here today for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. You have a misdemeanor case in this court. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type cases, whereas your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It's just that it just means that they're not as serious as the felony offense. The difference between the felonies and the misdemeanors basically is the range of punishment. For example, felonies are divided into into 5 categories. There's the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is anywhere from minimum of 6 months to 2 years in the state jail and a fine up to $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary and a fine up to $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if a person is convicted of a capital murder, the range of punishment, if convicted, is life or death. Now, for the misdemeanor cases, misdemeanors are divided into 3 categories. There's the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. You only can get a fine, you cannot get any jail time. Now, your Class C misdemeanors are cases that's normally handled in the JP court, which is the justice court, or the municipal court, which is the city court. For example, Class C misdemeanor could be a traffic ticket. A person not wearing seatbelt can get a Class C misdemeanor. Or if your inspection is out on a vehicle, you can get a Class C misdemeanor. And there are other offenses that are classified as Class C misdemeanors. And as I mentioned earlier, if a person is convicted of a Class C misdemeanor, the range of punishment is a fine only. Now, if a person is convicted of a Class B misdemeanor, which is the next highest misdemeanor, a person could be given 0 days to 6 months, which is 180 days in the county jail, a fine up to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor offense, the range of punishment is 0 days to 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such confinement and fine. Now, as I mentioned earlier, the case that you have in this court is a misdemeanor case. It's not a felony case. Now, as a defendant in a criminal case, you have rights. And one of the rights that you have is on the documents that you have on the clipboard. You have a right to have an attorney. The document that you have that is titled Judge's Explanation of Rights to Defendants Without Attorney states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may waive or give up your right to have an attorney and you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset, which means that it will be rescheduled to give you time to hire an attorney. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire, and that questionnaire is titled on the paperwork that you have, Jefferson County Affidavit of Indigence. You will fill that financial questionnaire out so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive or give up your right to have an attorney, you may not speak to the prosecutor. The prosecutor is the assistant district attorney. We have one here today, which is Attorney Lamar Jackson. Now, you may not speak to Miss Lamar Johnson. You may not speak to Attorney Johnson, the prosecutor, about your case unless you sign a written waiver of your right to be represented by an attorney. That is, there's a document that I think is the second page. It says waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Once that document is signed and you waive your right to have an attorney, then you'll be able to talk to Mr. Johnson about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome from you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left. If you want to waive your right to an attorney, which means you want to give up your right to have an attorney, and you want to represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line below that is titled defendant. And after you sign your name that's titled on the line that's titled defendant, you will place today's date on the line that's titled date, and today's date is January 3rd of 2023. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and representing yourself, then you would have to read and sign the next page that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. This is only for people who are waiving their right to have an attorney and desiring to represent themselves. Now, it reads as follows. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 3rd day of January of 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, you will sign your name on the line that is titled defendant, and you would date it today's date, January 3rd of 2023. As a defendant in a criminal case, you have other rights. Another right that you have is a right to have a trial by jury. And what this gentleman is sitting in that area over there, we call that the jury box. 6 citizens will be selected if you decide to have a trial by jury. 6 citizens will be selected to sit on your jury, and they will decide whether or not you are guilty or not guilty of the charges. You also have a right to waive your right to have a trial by jury or give up your right to have a trial by jury. And by doing so, you will not have a jury trial. However, your case will come before the court or the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. A bench trial is a trial by judge only. It's not a jury trial. And the judge will listen to the evidence. After listening to the evidence, the judge will decide whether or not you're guilty or not guilty. The other way that your case can come before the judge is by way of an unagreed plea bargain. What a plea bargain is, it's an agreement that you have worked out with the state. If you have not been able to work out an agreement with the state to settle your case, and you want your case to come before the court or the judge, we call that an unagreed plea bargain agreement. It means that you and the state have not been able to reach an agreement. However, you want the judge to decide what your punishment will be in your case. And if that's the case, your case will come before the judge, and the judge could either, the judge will assess punishment in that case. Now, the other way that your case can come before the judge is by way of an agreed plea bargain agreement. And what agreed plea bargain agreement is means that you and the state is the district attorney or the assistant district attorney, y'all have been able to reach an agreement or to settle your case. Now, your case will come before the court or the judge, and the judge will decide whether or not to follow, which means to go along with the plea bargain agreement or not go along with the plea bargain agreement. If the judge does not go along with your plea bargain agreement, you have a right to take your plea bargain back. In essence, for example, let's say you're in a plea of guilty to whatever charge, and the state is offering you, say, 1 day in jail, and it comes before the court, and well, you accepted that, and comes before the court says, well, I'm not going to go along with that plea bargain agreement. Then you have a right to say, well, judge, I take back my plea. In essence, I withdraw my plea of guilty. I'm not pleading guilty. You have a right to do that if the judge does not follow your plea bargain agreement. Now, if the judge does follow your plea bargain agreement, and if you decide that you would like to appeal your case, what an appeal is a higher court will look at your case, and they will decide whether to grant your appeal, deny your appeal. Now, that higher court is located right above us. It's called the Ninth Court of Appeals. They will review your case. They will decide whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. And if they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court in order for this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. The court that you can appeal to is called the Texas Court of Criminal Appeals. It is the highest criminal court in the state of Texas, and it's located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review, and I will explain that to you. Pro se means you will be representing yourself without an attorney, and you'll be filing the petition to the Ninth Court of Appeals, asking them to review your case to see whether or not you've been wrongfully convicted, whether or not the court committed an error by convicting you, or whether or not the Ninth Court of Appeals should have granted your appeal. Now, they can do one or two things. They could either grant your pro se petition, or they could deny your pro se petition. If they grant your pro se petition, then they could simply find you not guilty, and the case is over. Or they could send your case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, the conviction will stand. As a defendant in a criminal case, you also have a right to have witnesses to come to court to testify. Witnesses can testify for you or against you. If you're representing yourself, you could ask them questions. So if you have an attorney, your attorney could ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive, which means to give up your right to have witnesses to come to court. And by doing so, that simply means that you will not be calling witnesses, but it does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. You also have a right not to testify. We call that a Fifth Amendment right against self-incrimination. In essence, you have a right not to testify against yourself in your case. The state cannot force you to testify against yourself. It's normally referred to as taking the fifth. A lot of times you hear people saying, well, I take the fifth. That means I'm not saying nothing. You have a right not to testify in your case. Now, you can waive or give up your right. And if you waive or give up your right, your Fifth Amendment right against self-incrimination, you will be testifying in your case. Now, you also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. You have a right to see the documents, the witness statements, reports, videos, audio recordings, any instruments that they have that they're going to use in your case as evidence. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery, which means that you have a right to say, well, I don't want to have access, I don't want to have discovery, I don't want to have access to the evidence that the state has against me. Now, everyone that's here, you're here because you're out on bond. You've been arrested and you're out of jail on bond. You're either out of jail on either what is called a cash bond, which means that you pay the full amount of the bond to get out, or you're here on what is called a surety bond. A surety bond means that you pay a bondsman a percentage of what the total bond was, and we call that a surety bond. Or you are out on what is called a PR bond. PR bond means that you did not have to put up any money. You was released under your own recognizance. That's why we call it a PR bond. Now, if every day that you spent in jail, that jail time can be used as credit toward your punishment. So for example, let's say you spent 5 days in jail, and let's say the state is offering that you serve 5 days in jail to settle your case. What that means is you will not have to serve any more time in jail on your case, because the time that you have already served will be given to you as credit for time served. Therefore, you will not have to serve any more time on your case. In essence, you won't have to go back to jail. Now, if they offer 7 days and you serve 5 days, that means that you would have to do 2 days, because 5 days is subtracted from the 7. You'll be given credit for the 5 days that you've already spent in jail. Now, if the state is offering you a fine and court costs in this case, every day that you spent in jail, it is credited as $100 per day toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you won't have to pay anything. Why? Because the 5 days that you have spent in jail has already paid it off. And so you will be given what is called credit for time served. I mean, you'll be given credit for the time that you've been in jail. And so the fine and court costs will be what we call taxed and retired. You won't have to pay it. It's already been paid. Now, if they're offering you fine and court costs of $700 and you spend 5 days in jail, that 5 days in jail is $500 that will go toward the $7. That means you will only have to pay $200. Now, if you can't pay the $200 on the day that your case is settled, then the court can allow you to be placed on a payment plan. In essence, you could pay off the remaining balance in monthly installments. But let's say even if they put you on a payment plan, you will not be able to pay it off because you have no source of income. Well, that's not a problem because the court can allow you to serve community service. Every hour that you serve on community service, you get $12.50 that will go toward your fine and court costs. So if you work 8 hours of community service in a day, that's $100. Okay. Now, Jefferson County has a program that is called pretrial diversion. It's for people who have never been in trouble before. It's their first time. And what they will do, they will dismiss your case. And you can get it wiped off your record. We call it expunged from your record. And the way it works is like this. You have to, it has to be your first offense. You have to have an attorney to write the letter to help you get into the program. And the third thing, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. All other offenses qualify. And so you get into the program, they dismiss the case, you complete the program, then you can get it expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. Okay. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court, and it's for veterans only. It is also part of the pretrial diversion program. You get into the Veterans Court, you complete the program, they dismiss the case, you can get it expunged or wiped off from your record. The only criteria is that you be a veteran of any one of the branches of the United States military. Now, this court, County Court at Law Number 2, has a program that is called the CSI program. That's a program that I started within the first 100 days of taking office in March of 2017. So it's been 5 years. With that program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so we have that program to break the cycle. And that program that we have partnerships with agencies in the community. One of the agencies that we have a partnership with is Spindletop Center. It's our local mental health center in Jefferson County. And what Spindletop will do for any individuals who have mental health issues, now you don't have to be insane, you don't have to be incompetent to participate in the program. You can suffer from anxiety, depression, it could be bipolar, schizophrenia, a whole host of other mental health issues. They will do a private interview with you, either here or you can go to the center. They'll do a private interview with you. They will do an assessment, and they will develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, if you have issues with drugs or alcohol, they have a program that is called ATAR, and there's another program by our local drug abuse council that is called OZAR. Those programs are designed to address individuals who have issues with drugs or alcohol. They will do a private screening, will do an assessment, and then you will be referred for treatment, either outpatient or inpatient treatment to address your drug or alcohol addictions. The other program that we have, with other partnership rather that we have, is with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program, a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you get trained in one of those areas that you select, they will help you and assist you at getting a job in the area that you train in. Now, if you have not graduated from high school or you do not have a high school diploma, then CICE has a program, the GED program, where you could get your graduate equivalency diploma. Now, all of these programs that I've just mentioned are free. It does not cost you anything. The only thing you have to do is have a desire to participate in any one of these programs. And all of these programs that I just mentioned can be used as community service toward your fine and court costs. So for example, let's say you was ordered to pay fine and court costs and you cannot pay the fine and court costs. And then the court orders you to place you on or put you in a program to do community service. Now, if you're in the mental health program with Spindletop, or drug and alcohol, or the drug and alcohol recovery programs with either Spindletop or Ozar, or if you're working on your GED, or if you're in a job training program, any one of those programs that you're in, while you're in class being trained on the job for 1 hour, that's $100 that's $12.50 that will be going toward your fine and court costs. So you can kill 3 birds with 1 stone. 1, you're paying your fine and court costs. 2, you're in your program. And then 3, you're doing community service. In essence, you're doing 1 thing, but you're getting credit for 3 things. And as I mentioned earlier, all these programs are free. Now, these programs are designed to address the issue of recidivism. And we need to break the cycle. And the cycle starts off when people do not have an education, they can't get a job. Once they can't get a job, they get depressed. Once they get depressed, they turn to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. And once they commit a crime, they get caught and do time. But after they do time, they're going to get out. And so they're right back in that same circle, or back in that same cycle. And so this program is designed to address that cycle and to break the cycle of violence by addressing the issue of what we call recidivism. As I mentioned earlier, this program was started in 2017. And now in County Court at Law Number 2, we do not have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in the community in which we live. We don't have court as usual, we have unusual court. And as I mentioned, it's not because we're different, because we're trying to make a difference in the lives of individuals that come before the court and a difference in the community. And we're also trying to produce productive people. We believe that if we could produce productive people will not commit crimes because they have too much to lose. So in County Court at Law Number 2, we do not just give time, we take our time. And we believe that by addressing the issues that I've just mentioned, we can make Jefferson County a better place for all of us to live, work, go to school, raise our family, and go to church. Now, at this time, we will have Wade, who's with the Veterans Department. He's going to come and tell you a little bit about the Veterans Court program. Wade?
Thank you, Ron.
Thank you.
Good morning, everybody. My name is Wade Adair. I'm a veteran coordinator with the Texas Veterans Commission and the Spindletop Center. And I help veterans, their spouses, and their families. If you're a veteran here today, I'd love the opportunity to talk to you about touching veterans. If you're not a veteran here today, but you may have a veteran in your family, in your immediate family, or a friend that's a veteran, or a veteran that may need some type of assistance, regardless of what that may be. I'd love to be able to speak to you. So thank you very much for your time.
Okay. Thank you, Wade.
Thank you, Ron.
And then next we have Deputy Hinton. He's with Spindletop Center as our mental health officer. He's going to come before you and tell you a little bit about the program that Spindletop has.
Thank you, Your Honor. Good morning. My name is Steve Hinton, mental health deputy, licensed by the state commission with the sheriff's department here. The reason I'm here, the reason Brother Wade is here, is because the judge cares about every single person who comes before the bench. The judge has found, the statistics prove, is those who appear with legal issues commonly have mental health, substance use disorders, or just sometimes a lack of community resources that help you. The judge believes that if he can help you with these underlying issues, he can get you out of the cycle of arrest. Now, maybe this is your first time to be here, maybe it is your 10th time to be here. There's still hope. There's a program in place to help you. In accordance with the judge's CSI program, Spindle Top also has a court program where we work hand in hand. And I want to get this to everyone here before you leave here today, but also it tells you a little bit about the program, but also on the front has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, to help us, help you, I passed this out, this form, when you first came in. This is the demographic form. It is just like a medical document. It is private. No one will see this. It is just between you and Spindle Top. Should you take advantage of some of the opportunities that could be helpful to you, if you'll put enough information and say how you want to be contacted, either text, by phone, we're not here to inconvenience you or embarrass you in any way, but the only way we're going to be able to help you is if you take that step, reach out, allow us that opportunity to contact you so that we can work with you and provide resources that be best beneficial to you. If you want to speak today, we can do that as well. It's up to you. Again, we have a private place in the back. The judge has allowed us this opportunity and a location to speak privately where we can talk to you and work through whatever situation you may be going through, but we don't know. So again, we're asking you to take a bold step, share that need with us so that we can help you. If you have any questions, I'll be available once the court goes into recess. And before you leave here today, I'll pick up this form and I'll also hand each one of y'all this flyer so that you can hand it to take it home and use for. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, the program that I mentioned, or as I mentioned, is a program that doesn't just arrest the problem, but it addresses the problem. And so if you're interested in any one of these programs, just please let the court know, and then we'll be able to put you in the right direction so that you can address whatever issues or problems that you have. Now, the paperwork that you have on the clipboard, if you need some help, we have court personnel here who will be able to help you with filling out that paperwork and make sure that the paperwork is complete. And I think for those of you who will be requesting to have a court-appointed attorney, you would have to fill out that document that is titled Jefferson County Affidavit of Indigence. And you'll note that under the document where it says this portion to be completed by or with defendant, you're going to put your name, middle initial, your name, your date of birth, your address, your phone numbers. And you also, if you receive any type of benefits such as Medicaid, SSI, SNAPs, TANF, or public housing, you're going to check the appropriate box. If you are employed, you would check yes, and you state where you're employed and what type of work you do, the number of hours that you work, and how long have you worked at that job. Now, it also goes to your marital status. If you have to check one of the boxes, either single, married, divorced, widowed, or separated. And if you're married, you're going to put your spouse's name, middle initial, and last name. If you have any children that are anywhere from 18 years old or younger, then you would place the name of your child or your children and their ages on the column that says age. Now, as for residence information, if you rent, you're going to circle rent. If you own a home, you circle own. If you reside with family members, you circle yes. If you're homeless, you circle yes. Now, for monthly income / assets, which is at the bottom left-hand side of that document, you're going to fill out each one of those lines. For example, it says my take-home pay. If you are, whatever your take-home pay is for that month, not the week, the month, you're gonna put it in the space next to my take-home pay. If you have a spouse that's working, you put their take-home pay there. Now, if you're not working, you're just gonna put zero. If you don't have a spouse that have take-home pay, just put zero. If you are receiving child support, you're gonna put that amount. If you're not, just put zero. If you're getting SNAP, put that amount. If not, put zero. Social Security, put that monthly amount. If you don't receive that, put zero. Other governmental checks, you put that amount. If you don't receive any governmental checks, put zero. It says other income. If you have other income, you'll place whatever you're getting for the month. If not, put zero. If you have any assets, like if you own a home, a car, etc., you'll just place that amount in that line. And then at the bottom where it says total monthly income and assets, you will add up what's in that column, and then you total it, and it'll be the total monthly income and assets. Now, to the right of this document at the bottom, it says monthly expenses. So if you're paying rent or mortgage per month, you're gonna put that in the column to the right. Now, your utilities is your gas, water, light bill. You add all of that up per month and you put it in the column. Now, if you don't have that, you just simply put zero. Now, if you have child support, if you have to pay for expenses for your child or your children, besides child support or in addition to child support, you'll just add that up what you're paying per month. Total food expenses, what are you paying a month for food expenses? A lot of times people say, well, I don't eat that much, but then when we add up, when we tell them to guess how much they're spending a day, once they, for example, if they say $20 a day, once they multiply that times 30, they realize that they're spending more than they thought they were spending, or not only for yourself, but also for your household. Now, transportation costs. If you're paying a car note, if you're paying car insurance, and if you're paying for gas, transportation costs, all of that, you're gonna add that up what you're paying per month. If you have a cell phone or a home phone, you're gonna place that amount there. If you're on probation or parole, you'll place that monthly amount to the right. And if you have any medical or health expenses, place that amount to the right. And if you have any credit cards that you're paying on, they want your minimum amount that you pay per month, and put that. And then once you get to the bottom where it says total monthly expenses, you're going to add up everything in the column above it, and then you will total it. And the next page where it says defendant's oath, you say on this, the third day of January of 2023, you'll read this oath, and then you'll sign where it says defendant's signature and today's date, January 3rd of 2023. And then where it says unsworn declaration by defendant, you're going to place your name, your middle name, your last name, your date of birth, your address, city, state, zip code, and account and the country, which is USA. And then at the bottom, it says executed on the third day, or executed in Jefferson County on the third day of January of 2023. And then that will be all that you would have to sign. And then the court will have to fill out the rest of this document. Now, again, if you need any assistance, we have our court personnel who's ready to help you. And this is going to take some time for everybody to fill out. And then once you've finished filling out the paperwork, we're going to take the paperwork up, and then we're going to call you up one at a time, either to reset your case because you want to hire an attorney, or to review your affidavit to see whether or not you qualify for court-appointed attorney, or to see if you want to waive your right to an attorney. And if that's the case, then you'll have an opportunity to talk to the prosecutor in this case about, or in this court about your case. So at this time, the court is going to be in recess to give you time to do that. Now, if anyone needs to use the restroom, there's 2 restrooms out in the hallway. If you go out the door, it will be right in front of County Court at Law number 3, which is next to the right of this court. That's the male restroom, and the female restroom is on the other side in the lobby in front of the district court, the 172nd District Court, which is Judge Templeton's court. That's what a female restroom is. Now, at this time, the court will be in recess to give you time to fill out the paperwork and to give the court time, the court personnel time to go over this paperwork, which the court will be in recess.